Thank you.
All right, no problem. So it wasn't too bad, like trying to get the DC up here.
I know. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, March 11th, 2026. We have 8 bills on the docket, and we're going to start off with Senate Bill 919. Senator Lewis Young, welcome.
Thank you. As you mentioned, I am Senator Karen Lewis Young, District 3. Thank you for the opportunity to present this bill that will involve greater transparency communication from HOAs. I'm sure we have all received complaints from our constituents who reside in HOAs. And if you've ever served in local government, you have probably heard even more. The kinds of things we hear are lack of transparency, unanswered questions, poor communications between HOA management and residents, unexpected policy changes, strict and unevenly enforced rules, special assessments, rising fees, and lack of meeting accessibility. This bill, I believe, will address 5 of those 7 issues. I will also tell you that to some extent, this bill is modeled after a bill that passed unanimously in Florida last year. Florida's HB 913. However, their bill was 200 pages. My bill is 7 pages. I hope you appreciate that. They did a much more comprehensive look at HOA issues and tried to put parameters around those strict and unevenly enforced rules, like if your pumpkin's out 2 days after Thanksgiving, you get fined, or your lights are up 3 days after the holidays, you get fined. I just didn't even want to get into that because how do you pick and choose? So that's why this bill is much more focused. I want to give you a little bit of background about HOA population. Approximately 17% of all Marylanders live in HOAs. This is about 1 million people. There are about 7,000 HOAs in the state, which cover between 400 and 500,000 homes. What this bill does is require homeowner associations of 100 or more lots to electronically make available their articles of incorporation, their bylaws, rules and regulations, meeting minutes for the past 12 months, recordings of the governing body's meetings from the previous 12 months. It also requires HOAs to deliver meeting notices at least 2 weeks in advance. Notices must include time, place, and a hyperlink or call-in instructions for virtual meetings. Requiring HOAs to allow lot owners to receive meetings noticed electronically is really helpful, because if you're just counting on a piece of paper stuck in your fence or front door, it can get blown away. You might be out of town and never even know about the meeting. This also permits HOAs to secure a loan or a line of credit to fund reserve study accounts upon a majority vote of the lot owners. You may recall a few years ago, it was probably 2 or 3 years back, based on the Florida condominium building that collapsed, many states required excess payments and a reserve account to anticipate those kind of catastrophic events. It was an inordinate burden on residents, and this ability to develop this line of credit is a backup for that kind of situation. So what are the benefits? Increased transparency, probably increasing voting rights. That's been the experience. Increased accessibility. Many HOAs, I know the one I live in, has a lot of elderly residents, and they don't drive after 7 o'clock at night. And so they've missed meetings. Also, it's beneficial for disabled individuals and parents that aren't going to leave their children home alone to attend an HOA meeting. This bill will include not only accessibility, but responsiveness, reduce these excessive punitive actions by simply informing people what the rules, what the changes are, and contribute to a more equitable, harmonious relationship. I also believe that electronic voting and important documents on a website can reduce HOA costs. And I did mention the access to credit line. It also makes, when it's required for a quorum to exist, being able to participate in a virtual meeting makes it much easier. I do want to mention a success story right here in Maryland. Fishing Creek Farm HOA on the waterfront in Annapolis. They made the transition to website, electronic meetings, and without telling you the whole story, the summary is it's smoother, it's more convenient, more accessible, increased participation, stronger communications, and minimal costs. They've actually reduced their costs from printing postage and freeing up staff. You will see one piece of opposition saying that this is costly, impractical, and there may be a constitutional issue. So I do want to address that. I think I've already addressed the costs, potential cost savings. I did check on website costs. For HOAs, they can be as little as $200. The average is between $500 and $1,000. Maryland is an all-party consent state, making certain forms of video and audio recording illegal. But I actually got an advisory letter in 2023 from the AG because it came up in one of my communities. A citizen was told, oh, we can't record the meetings because it's a violation of wiretapping laws. And I'll just read you a few sentences from Catherine Rowe, dated June 20th, 2023. You have asked for advice concerning whether Maryland's wiretapping and electronic surveillance law, courts and judicial proceedings article would prevent the taping of a meeting, the taping of a meeting of an HOA. It is my view that it would not. Clearly, then, a person has no expectation of privacy in the statement that is knowingly exposed to the public. Clearly, then, a person has no reasonable expectation of privacy in statements made in an HOA meeting that is open to the public. I think that's the essence. Finally, the implementation date for this, when HOAs would actually be required to have a website or an online portal or mobile device application, is October 1st, 2027. So that would give them a substantial amount of time to develop them. So with that, I urge you to adopt a favorable report of this very common sense bill that will help communications and transparency in HOAs. And turn it over to the rest of my panel. Thanks.
Hello, Senator Smith, Senator Wallstriker, the rest of the Judiciary Committee. My name is William Steinwhittle. I'm the Deputy Advocacy Director for Homeownership Preservation at the Maryland Legal Aid Bureau, and I'm testifying in support of this bill with the invitation of Senator Karen Lewis Young. So one of the things the bill would require was that within 30 days of the creation of, or receipt of financial records, they would be made available to all homeowners. So as the senator said, when older homeowners aren't able to attend the meetings, sometimes they don't really know what to do if they run into a problem paying their HOA fees. And then they run into a problem and then they don't know where to go. So I think that this bill would go a long way to alleviating that issue. In addition, sometimes the management and procedures in an HOA can change rather quickly. And this bill would create more transparency and allow more homeowners to know exactly what was going on. We once had a client who the management company changed and she suffered from severe disabilities and was not aware of that. And then she continued to send the payments to the old management company thinking that was okay. And it turned out she was sending them to the wrong place. We were able to assist her by filing bankruptcy, but if this bill had existed at the time, it's possible that the situation could have been avoided. Finally, this bill would bring more transparency to the finances of an HOA by making their financial reports available. About 10 years ago, we investigated an HOA that we believe was doing some fraudulent behavior. And a lot of the homeowners had a lot of very big concerns about where the money was actually going. I think this bill would go a long way towards bringing transparency to the HOA industry. So for those reasons, I testify in strong support of Senate Bill 919.
All right, thank you very much. All right, questions from the committee for this panel? We had Senator Muse first, and then Senator Sidnor.
Thank you very much, Senator. Thank you for putting this bill in. It is really needed. I get horror stories about those who are in leadership positions on the, whatever the homeowner, whatever, whether they use president, chairman, whatever. My first question is, who makes the policy? Is it everyone gets to vote? All residents get to vote on things like Christmas lights? Because I would have voted no. I'll keep my Christmas lights up until February, March. I just like them until I'm told by my wife to throw them out.
Our residents don't get to, I mean, each HOA is different. That's part of the problem too. The board of trustees makes a lot of decisions, and frequently they get a bit carried away. So this doesn't even address who votes.
Okay, I know that just wanted to have for my own knowledge, because I get complaints about no reports on finances.
So
Liens on homes.
what the transparency does, though, is it forces the board to put out an agenda in advance so that if you have a question or an issue, you can join the meeting, whether it be electronically or in person. So it facilitates what you're speaking to by advance notice.
And okay, thank you, Mr. Chair.
Senator Sidnor.
Thank you. Two questions. One, I was looking on page 2, lines 32, 33. It talks about 100 lots. I'm just curious, where did that cut off? Why that cut off? Because you have, I would assume, any HOAs that are less than 100, this doesn't apply?
Why did we use 100 as a cutoff? You had a cutoff somewhere.
You wouldn't want to make it applicable to all HOAs?
The bills, that's up to your committee if you want to change it.
But you're the sponsor.
In part, I looked at what Florida did because they spent a lot of time on this. And also, to me, it seemed reasonable. And I felt that for the smaller HOAs, it might be a bit more difficult to implement. They don't necessarily have staffing.
And the second question was just in terms of notice, because even those organizations that may have 100 lots, what I find is most of these HOAs are governed by volunteers who have absolutely really no idea about corporate law.
Yes.
So to get them, to ensure that they have notice, what are you envisioning as the mechanism? Is it the legislators, after we pass it, putting something in our newsletter to let all our HOAs know this new law is in place, or what are you thinking?
I'm wondering if you could help me out with that. I mean, I know that I will find in my own community a way to communicate to all the HOAs in my district. I'll have to look and see if there is a state entity that could assist us
And I
in.
thought, what this, was the Secretary of State, or I thought it was some agency that if you wanted to be
Yeah,
recognized a
that's a
certain
good
way.
question, because what good is the bill if we can't communicate it?
that's the whole thing.
I will tell you, in Florida, that's a problem, because the bill was passed last year, and
Nobody knows it's there.
it has not been communicated to the HOAs.
Okay, thank you.
It's an excellent point, thank you.
Thank you so much. Any further questions for the sponsor of this panel? If not, we'll move on to the opponents of the bill. Thank you, Senator, so much for being here. It looks like the testimony is virtual. Vicki Kane. Is Ms. Kane with us? Ms. Kane, looks like you are already unmuted, so you are good to go. Please go ahead. Ms. Kane, if you can hear us, we are ready for your testimony, so please don't hesitate. Go ahead, and looks like you're already unmuted, so you can just start when you're ready.
Thank you very much. I'm glad to be here. Senator Smith and Senator Waldstreicher, my name is Vicki Kane, and I represent.
So, Ms. Kane, I think you're getting some feedback because you probably have the YouTube going in the background. So if you can turn off the YouTube version of the streaming and just be in the Zoom part of the hearing, that'll allow you to testify without feedback.
Okay, I think we've taken care of that.
Okay, we'll restart your time.
Senator Smith and Senator Waldstreicher, thank you very much for listening to me. My name is Vicki Kane, and I am a member of the Maryland Legislative Action Committee, and I'm here today to speak in opposition to Senate Bill 919. We have discussed it and found that for several reasons, it's not a feasible option. Even if you're starting at HOAs that have 100 lots. What we've seen is, and we've seen this not only with HOAs, but also with condominiums, is that in order to get something up and running, one of the things you have to have is you have to do training. And that for the most part, we don't feel that this bill, no matter how simple you make the website, that it would be possible to get everybody trained so that they will use it in an intelligent manner and use it frequently. I'm in a condo. We're just starting with a website, and we have about 200 units, but less than half of the people ever use the website. So this is one problem in getting the information out. You still have to post notices. You may still have to call people. Besides the fact that Maryland is an all-party consent state, and there could be issues if a board member is having a meeting with other members, and that has to be recorded and posted. So for these reasons, we would like to vote. We hope that you will vote unfavorable for SB 0919. Thank you.
All right, thank you very much. Are there any questions? If not, I believe that concludes the hearing on Senate Bill 919. Thank you very much. Next, we'll have Senate Bill 814.
Should have someone else join. Good afternoon, Mr. Chair, members of JPR Committee. I'm Senator Antonio Hayes, representing the 40th Legislative District. It's my second time before this committee this session and my last time here, but the first time was so good. I brought back 3 bills. And so thank you all so much for your support and sending my bill out of here. All right, this bill, Senate Bill 814, Residential Property Service Agreement, Defunct Service Providers. As you all may remember, a few years ago, companies began offering homeowners what appeared to be harmless service contracts, offering things like home maintenance or listing services. In exchange, the company would record a document against the property, often creating something similar to a lien or encumbrance. These agreements could last years, sometimes even binding further homeowners if the property was sold, and most of them targeted seniors in our community. In 2023, we, the General Assembly, passed legislation to regulate these types of agreements moving forward. Yet the problem is many of these agreements were signed before the law took effect, with some of the companies since going out of business or forfeiting their right to operate in Maryland. So what we're seeing now are zombie agreements, contracts that still cloud a homeowner's title, even though the company behind it no longer exists or is not in good standing with the state. Senate Bill 814 provides a solution to these pre-2023 agreements tied to defunct companies. Under this bill, these agreements become void and unenforceable if they attempt to last for more than 2 years, run with land or bind future property owners, create lien or encumbrances on a property, or allow the contract to be assigned to another company without notice or consent. If one of these agreements has been recorded against a property, the homeowner can go to circuit court to have it declared void. Senate Bill 814 gives homeowners a clear legal pathway to clean their property title and ensures that Maryland homeowners are protected from these predatory agreements. Senate Bill 814 is a straightforward consumer protection measure that helps homeowners resolve lingering problems from contracts signed before 2023. And for these reasons, I respectfully request a favorable report on Senate Bill 814.
Thank you. Is Ms. May on your panel or just testifying?
I'm sorry?
Is Ms. May on your panel? Is Maryland Realtors, are they on your panel?
Yes.
So have her testify, and then we'll take questions from the committee. Thank you.
Thank you for that introduction. Lisa May with Maryland Realtors, and we thank Senator Hayes for bringing this bill. As he mentioned, we estimate that there were about 1,000 of these agreements that were finalized before the passage of legislation in 2023. And these are starting to show up in real estate transactions now. In the fall, we heard of an instance in Harford County. It was an estate. The parent signed up for one of these agreements. The heirs had no idea, so they went ahead and listed the property for sale to dispose of the estate. Well, a packet arrived in the mail and said, you did not list this property with the brokerage that is in the agreement. Therefore, we're demanding our 3% of your home's value as a penalty in order for you to complete this sale. Also, last week, we heard of an instance in Hagerstown. A gentleman had signed one of these agreements. A notary showed up at his door. He signed paperwork, received $700. never got a copy of the signed agreement and has had difficulty refinancing his home because of the presence of this in the property records. He is now meeting with a realtor to see if he can sell the property, but that is very much unclear given the status of this agreement. So these are going to continue to cloud titles, to prevent refinancing, create difficulties in sales, not just now, but many, many years from now. And even when this company is long gone out of the state of Maryland. So we think that that's worthy of your attention and your consideration, and we ask for a favorable report.
Thank you very much. I see no questions, but I have one. Would you mind so the service contracts that we're talking about, they're real estate brokerage contracts? So what kind of contracts are it?
So it's not a brokerage agreement in the sense that you might think that it is. And in fact, this company argued that it was not a brokerage agreement. It was a services contract where one day you might enter into a brokerage agreement if you want to, but if you choose not to, then that's where the penalty clause comes in. So right now, because this brokerage is no longer around, you don't even have the option to use the brokerage clause of this. Really what's left is the penalty. And if the company ceases to exist with SDAT, then you just have this mention on the title without really a clear way to resolve it.
So these are essentially sales agreements. I guess are these real estate salespersons who have these agreements that I guess I'm trying to visualize what's going on here.
The best explanation we had was this was an agreement to one day enter into a brokerage agreement.
I got you.
And that is kind of how they have gotten around the brokerage laws, the regulation from the Real Estate Commission. People got creative.
Got you. Thank you very much. Senator James.
Since you mentioned Harford County, do you want to just give me a little more details about the case and how it was resolved?
I believe that one was resolved because it was an estate, because the heirs essentially were not necessarily expecting any sort of windfall. It was my understanding they were contemplating just paying the penalty so that they could move on and close out the estate.
So they were, okay, so really wouldn't fall under this bill?
It wouldn't fall under this bill if it's already been resolved, but, the impact was they needed to pay probably $10,000.
I thought the bill applied, the entity still exists. This is for defunct entities, right? It sounds like you're saying the entity that was involved in the estate still existed and was in a position to enforce whatever the agreement was, which is different. I just trying to understand. You gave an example, but I don't think it falls under this bill, does it?
No, I believe that you're right. At the time, the entity still existed. It was not in good standing, but it had not yet forfeited with SDAT.
Right.
Correct.
Okay. All right. Thank you, Mr. Chairman.
All right, thank you. I believe that ends the hearing on Senate Bill 814. Would you like to do 811 next, Senator?
Indeed. Senate Bill 811, right? All right. It's my second bite at the apple. I do want to take a point of personal privilege. Mr. Chair, I believe my constituent Maple Gordon is here. So I'm here to look good in front of my constituent. So don't embarrass me. Let me let you know. All right. So good afternoon again. I'm Senator Antonio Hayes. I represent the 40th Legislative District in Baltimore City. And I'm here to present Senate Bill 811, the real property, new home sale, entry for final sale price, and multiple listing service. This bill is a priority of the Maryland Legislative Black Caucus. It seems straightforward, but it is a necessary measure designed to improve transparency and accuracy in Maryland's real estate market. As you may know, a property appraisal and valuation equity task force was established in 2022. The task force was assigned with identifying policies to address and reduce bias in property valuations. Their key recommendation was timely reporting of new residential construction sales through a multi-listing service or similar mechanism. And this is what Senate Bill 811 serves to do. For more context, when a home is sold, the final sale price is typically recorded in multi-listing service. A database real estate professionals use this to track property sales and market activity. However, when a newly constructed home is sold directly by a developer, those final sales are not always entered into MLS. This creates a gap in data which primarily affects communities of color, where these gaps and undervaluation concerns have been documented. Senate Bill 811 addressed this gap by establishing a simple and uniform reporting requirement, creating consistency and accessibility in sales data that would strengthen Maryland's overall market. This bill requires that within 30 days after the sale of a new home, the developer, builder, broker, or real estate agent must enter the final sale price into the MLS system or similarly accessible database. Why is this important? First, it helps ensure more accountable appraisals. When all sale data, including new construction, is available, appraisers can produce more reliable property valuations. Second, it improves market transparency. Buyers, sellers, lenders, and real estate professionals all rely on accurate sales data to understand the true value of homes in a neighborhood. And third, it protects consumers, specifically Black and brown communities, who are facing the negative impacts of inaccurate and missing data. MLS is one of the primary sources of information used by real estate professionals, and more importantly, when appraisers are determining fair market value of their homes, Delia Taylor has been working closely with Bright MLS, which Delia Taylor, who happens to be my cross-file, has been working with MLIS, which garners most of the MLS business in the region, to consider a reporting project structure that is more flexible to developers and builders, one that recognizes operational differences while still ensuring transparency. By ensuring that a final sales price of a new home are reported consistently, it allows Maryland to strengthen the quality of data used throughout the housing market. For these reasons, I respectfully request a favorable report on Senate Bill 811.
Thank you very much, Senator West.
Thank you, Mr. Chair. Thank you for bringing the bill. I've got a couple of questions, though. So the bill uses the term sale. Now, when you sell a house, first of all, you enter into a contract to sale, and then a period of time typically follows where there's a home inspection, financing is obtained, all the title work is done, and you finally go to closing. So does this term sale intended to refer to the execution, the date the contract of sale is executed, or the date that the home transfers title from the old owner to the new owner?
It's a good question, one of which I'm not sure if I have an answer, but within 30 days after the sale of a new home in the state, a developer builder, yeah, it's probably after the closing, once the transaction has been finalized.
Yeah, I figured probably going to say that. So I'm not real adept at this stuff, but my son, who a year ago bought a townhouse out in Timonium, was really good using Zillow. And he would constantly tell me, Dad, there was a house 2 blocks away from you that sold for X dollars. And apparently all he needs to do is look in Zillow and type in the zip code. Zillow must get access to this information from the land records and then put it up online.
Correct.
So if that's the case, why is this bill needed? If I can get the information from Zillow in 30 seconds, why would we want to require people to subscribe to this multiple listing service, which I think is a private organization?
Yeah, so one, good point. So MLS is a private organization. If you look at the bill text, it says MLS or a similar database, right? So it creates an opportunity for a similar database to be created to facilitate these things. The other thing is, where's in regular home sales, like in my community, which is an older community, it's well established. If there's a sale price, yeah, you might be able to find that. What this addresses is those new developments, those new construction developments that are brand new. It doesn't provide you the opportunity to see the comps when they're doing it as like a whole new development. And so the difference is, like those older communities, yeah, I mean, obviously he'd be able to share with you what those sale prices are. What you don't necessarily see is the sale prices when you have a brand-new development.
So Zillow doesn't report the sale prices of homes that are sold for the first time that have recently been built?
Zillow may, I'm guessing.
There's a lot of
Yeah. Oh, go right ahead. No. Jump right in. No. Yeah, sure. Thank you.
We're going to stick with Senator West, and then we can come to you if you want.
No, I just, so I guess my fundamental question is, since you can get this information effortlessly in seconds from Zillow, why do we need to have a bill that requires people to either subscribe to the multiple listing service or find some other separate service and report the same information to them that already is being reported free of charge on Zillow?
Yeah, I think MLS has, like, you might get the sale price, but MLS has different details that's available to real estate professionals that may not be available on a free platform like Zillow, right? And so when that's the answer.
I got you. Thank you.
All right, cool.
Senator?
Hello, Senator. Thank
Hey.
you for bringing the bill.
Yeah.
I believe there was a work group that studied appraisal bias, and this was one of the recommendations from the work group, wasn't it?
Yes, absolutely.
And when they were sitting down with new home developers and with people who had experienced the appraisal biases, one of the things that they noted is that when new homes are built next to existing homes, that the new homes are often sold by the home developers. Was that the case?
Correct.
And that if you have like a Ryan Homes or Hovanian or any of the big companies that build these new communities, that what the big companies were doing is handling those home transactions in-house, so they might not have a realtor that was doing the home sales. Is that kind of how they were doing it?
Absolutely, and it didn't provide the type of transparency that folks needed to look at the comps in comparison. Correct.
Fantastic. With this bill, would it require them to, even if they were doing those home sales in-house, to make sure that they were reported on the multiple listing services so that realtors who were assisting buyers with other home transactions would have access to those for the comps?
Absolutely.
And would that help with some of the goals? I think you mentioned this is a priority of the Black Caucus. Would it help with some of those broader equity goals?
Yes, absolutely.
Thank you very much, Senator. Thank you for bringing the bill.
Thank you, Senator Hinton. I appreciate it.
Seeing that there are no more questions, thank you very much, Senator. Next we have Ms. May
All right.
from
Is
Realtors.
this 817?
No, we still have favorable with amendment and an unfavorable.
Oh, gotcha. Okay. All right. Thank you. I was all excited.
Thank you. Again, Lisa May with Maryland Realtors. We are here favorable with amendments. As was mentioned, the multiple listing service is a private organization, as you'll note in our written testimony, and our local realtor associations, the ones that are in each of your communities, are shareholders of that corporation. And so first, we just wanted to be very clear and very transparent that should this pass and there be extra subscribers to the multiple listing service, that some of our local associations may in fact financially benefit from the decision that you're making here today. And if it is your goal not to essentially require the use of a private for-profit service, we would be very supportive of coming up with an alternative, as is already mentioned in the bill, the other substantially similar database. And it's entirely possible that we may even have a consensus bill if we could come up with an alternative to the MLS when it comes to this bill. And at that point, I'd be happy to take any questions. Thank you.
Senator West.
Hey, let me go back to my earlier couple of questions about Zillow. You're in this industry, so you deal with these things every single day, which I don't. And so you know much more about this than members of this committee. If you wanted to find what the recent sale price of a home was, can't you use Zillow and get the answer?
I think some of it may have to do with the timing of how quickly SStat or Zillow is updated from the time that it gets recorded in the local office to when it gets republished through some of these sites. There's also instances where, new homes are not sold using real estate professionals. They use in-house employees. I can't really speak to that. When they are listed through realtors, oftentimes they are directly input into the MLS, but that's not always the case.
Okay, now I know nothing about Zillow, but once my son started reporting what houses in my neighborhood were selling for, I got interested in it. And because in years past, I had done some real estate work, and I'm familiar with the titling system and how deeds are recorded in the land records. My working hypothesis was that Zillow simply took a pass through the electronic land records daily and then acquired the information about recent sale prices as reported in the land records. So if that's the case, and since the senator said that this bill is pings on the sale, which is the transfer title of the new home, and requires within 30. Now, normally when title for homes are passed, the deed is recorded either instantaneously or contemporaneously, at least, in the land records. So if Zillow takes a pass daily and collects all the new information about deeds that are recorded that day, it would strike me that the sale price of the houses would be more quickly reported on Zillow than if you waited 30 days to report the sale to this commercial for-profit multiple listing service. Am I right on that or wrong?
I know that the recording at the county level, in the county clerk's office, that recording happens very quickly because then that's how the funds are dispersed and all of those things take place.
And those recordings these days are electronic?
Yes.
Okay.
Most of them are.
Right.
It's the handoff between the local clerks and SSTAT that I believe can vary. Now it is 2026, and we would hope that technology would allow that to happen very quickly.
Okay. Thank you for your answers to my questions.
So based on your written testimony, it seems as if it already includes the other option other than MLS. So what is the amendment that you're seeking? Is it to exclude MLS and just kind of mention just another system? Is that what you're, okay.
Yeah, I believe that would be our amendment, is to strike MLS or.
Okay, thank you.
You may not be the right person, but since we're bringing up Zillow, there's a number of, because I use these quite a lot, but there are a number of these. There's Zillow, there's Redfin, and I could go on. This could be and anywhere from like a half dozen. It's very competitive. It is in their business interest to get this information out as accurately as possible and as frequently as possible. So now I'm just a little behind the eight ball in understanding. I get wanting to make sure the information's out there, but even if we took out multiple listing services, do you read the bill that would this could be accomplished without anybody having to pay any money to get this information out there? Because as my understanding, these are all free services, right? And maybe somebody else can address this, but also the idea that I've never heard that any of these apps don't want to put all the information they can possibly get about a sale online, including a new sale and a new development. It is in their interest to get that information out there. But do you have any understanding of whether these new apps are helping the circumstances or not helping the circumstances that the senator's interested in?
I do not. I don't have any knowledge of the inner workings of Zillow.
All right, so we'll have to get, I think there's some other people that'll testify. All right, thank you.
All right, further questions from the committee? Seeing none, thank you very much. Thanks. Yep. All right, so that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel. Is Lori Graff here? Welcome.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Lori Graff. I'm the CEO of Maryland Building Industry Association in respectful opposition to Senate Bill 811. You've heard a lot about this bill. We have been working very closely with Delegate Taylor on this issue for a couple years now. I was on the task force that was mentioned earlier. We spoke our opposition at that point as well. We just have a lot of concerns with the language in the bill requires multi-list service or another similar database. That other similar database does not currently exist. So it is MLS, which is privately owned. So we have some real concerns about mandating an industry to use a privately owned company that you have to subscribe to. Our issue is not about transparency. All of the recordings do go to land records. They then eventually make it to SSTAT. I know there's some concerns about the timing of when SSTAT gets the data, and I think that's something that obviously we should look at. In the 2026, we should be getting things a lot quicker. The other thing I would like to point out is some of the counties, specifically Anne Arundel, Howard, and Montgomery, require builders to build for sale moderately priced dwelling units, MPDUs, and those are going to be priced drastically different than market rate. They're drastically differently priced. So if you're putting that in MLS, the MPDUs, and it doesn't necessarily achieve the goal of the comps, because those should not be comps. So that may require some type of an amendment of some sort. But with that, we asked for an unfavorable report. We are happy to work on the issue and have had conversations with Delegate Taylor about working on it further over the interim. So happy to answer any questions.
Thank you very much. Questions from the committee? Thank you very much. Thanks. With that, that'll conclude the hearing for Senate Bill 811. We'll now go on to Senate Bill 817. Senator Hayes.
All right, last bill of the day. Welcome back, Mr. Chair. Thank you so much. I'm Senator Antonio Hayes, representing the 40th Legislative District for the record. And, excuse me, I'm here to present Senate Bill 817, Real Property, Residential Sales, Communications During Appraisal Process. This bill, colleagues, was actually modeled after the federal government's Veterans Administration reconciliation process, which aims to, protect veterans and the valuations of their property. Under the recommendation of the Task Force Property Appraisal and Valuation Equity, Senate Bill 817 seeks to create a reconsideration value process for the state of Maryland. This bill is one that is a priority of the Maryland Legislative Black Caucus. This bill was initially passed through the House last legislative session, but ultimately stalled in the Senate. Since then, we have taken the necessary steps to address those challenges and would like to acknowledge the continued engagement from the Maryland Mortgage Association, the Maryland Realtors, and the Maryland Bankers Association. Appraisals play a critical role in home buying and lending process. However, many studies have shown that Black and brown communities are consistently undervalued in comparison to neighborhoods that are predominantly white. This often leads to deals falling through, buyers losing financing, and sellers may be forced to lower price of what is often their largest financial asset, their home. Senate Bill 817 creates a review step in the appraisal process. Under the bill, for a sales transaction, if an appraiser makes a preliminary determination that a home may appraise below the contract price, the appraiser must notify the designated point of contact and interested parties before completing the report. Senate Bill 817 allows the seller or seller's agent to submit additional market data or comparable sales when requested by a lender or lender's appraiser. When refinancing or for a home equity line of credit transaction, the homeowner or their representative may provide additional market data or comparable sales if the appraisal value falls below expected. Senate Bill 817 does not override the independence of the appraiser. Instead, this bill improves the accuracy and transparency of home valuations. This bill helps ensure appraisers have access to the most complete and current market data available before finalizing a report, and ultimately protects the equity of Maryland homeowners by addressing long-standing inequities in property valuation. Senate Bill 817 establishes a clear and responsible communication process that benefits home buyers, sellers, lenders, and appraisers alike, and ensures Maryland homeowners receive fair and accurate valuations. For these reasons, I respectfully request a favorable report on Senate Bill 817.
Excellent. Thank you very much. All right, we're going to hear from, we have several folks signed up favorable with amendments. We're going to hear from those folks, and then we'll open it up to the committee for questions. So Lisa May, Mr. Enton, Robert Enton, and Evan Richards.
Thank you, Mr. Chair, members of the committee. Robert Enton on behalf of the Maryland Bankers Association. I have to tell you, I've spent a tremendous amount of time looking at this issue during this session because it's critically important. Appraisals, how many of you have gone out and paid for an appraisal on a piece of real property for anything other than when you applied for a mortgage loan? Banks, mortgage lenders are required by both federal and state law to have an independent appraisal judge the value of the property if they're going to take that property as collateral. So we are the cornerstone of the appraisal process and appraisal regulation is the independence of the appraiser. And the concern we have with the bill is with maintaining that independence. You have pretty detailed written testimony from the Real Estate Valuation Advocacy Association and from the Appraisal Institute. It's pages on and on. But it is pages on and on because the appraisal process is so heavily regulated at the state and at the federal level. Our concern is that provisions in the bill which require or allow for a third party to intervene in the appraisal process could have a negative impact on the independence of the appraisal. In addition, it is heavily regulated at the federal level because of the impact on lending. Finally, I would tell you that there are just some specific provisions in the bill. For instance, it requires lenders and appraisal management companies to monitor appraisals for compliance. We're not in the business of monitoring for compliance. I'm signed up, and I'll wrap up, Mr. Chair, favorable with amendments because we very much would like to work this bill out. I met with the sponsor earlier today, and if we can come up with some amendments that would address these concerns, we would very much support the bill. Thank you.
Excellent. Thank you.
Thank you, Mr. Chair. Again, Lisa May with Maryland Realtors. Realtors have supported a reconsideration of value process at the federal level for its importance, not just of providing additional comps for consideration, but also to correct errors which may occur on the property itself that is being appraised. But realtors are, by design, a step removed from this process to maintain appraiser independence. So our comments on this bill are going to be limited just to those that impact realtors and consumers at this point in the process. So first on page 2, when it talks about the submission in the form of the comparable sales grid, if you have someone who's working with a real estate professional, they can probably track down that sales grid, find the information that needs to go on it. But if you're a homeowner working by yourself, a buyer or a seller working for yourself, are you going to be able to do that in the 2 days that is allotted under the bill? We have some concerns that a typical property owner would not be able to do so. And then again on page 3, beginning on line 8, it talks about the submission of pending home sales as potential comps. But line 8 says that in order to do so, you have to submit all contract documentation. That is not something that is going to be available to anyone outside of the 4 people who are involved in that pending transaction, the buyer, the seller, and each of their agents. So essentially, unless we are able to change that wording to something along the lines of all available information, we're essentially saying that pending sales will never be able to be used as comparables for this evaluation process. So again, we are not speaking beyond those points on this bill. I know that lenders and appraisers would be better able to speak to the other parts of it, but we request your consideration of those amendments. Thank you.
Excellent. Thank you very much. All right. So I'll call one more time. Evan Richards. Nope. All right. Questions from the committee. Senator West.
Mr. Chair, for Ms. May, this question about pending sales. My understanding has always been that appraisers take a look at comparable sales, in other words, sales that have actually occurred. Is it customary for appraisers to consider pending sales that haven't yet closed in making their appraisals?
I could not speak to that, not being an appraiser. It's my understanding that typically, yes, appraisers want closed sales because they are things that have actually occurred. Things can happen under contract where a sale falls through. You would also need to know what considerations were made. Was there cash back? Were there repairs that were made to actually get to the net, not just the contract price, but what it actually netted at closing?
Okay, that's always been my impression too. I used to work when I was in college for a local attorney in Towson who did all the work for a particular savings and loan. And so I saw appraisals coming in. I can't ever recall an appraiser relying on a pending sale that hadn't closed yet in terms of establishing the value of the property in question. Thank you.
All right, thank you very much.
Thank you.
So that'll conclude the testimony for the proponents of the bill. We'll now switch to those signed up in opposite.
Mr. Chairman, do you have a Richard Green registered to testify? We signed up on behalf of the mortgage bankers.
We don't have it here. Is it in the back? We don't have it signed up in the system. Is Mr. Green here?
He is.
So we'll allow it. Come on up and testify. Is this favorable? Yeah. Favorable with amendments? Favorable?
Unfavorable.
Unfavorable. Oh yeah. Well, hold on. If you could just have one seat, then so now we'll switch to the opposition panel. We're going to hear from Dennis Rasmussen first.
That's
you. You're in opposition.
That's
okay.
my AKA.
Oh, that's your AKA. Okay. Yeah. Just use the regular government name and we're good, man. All right. We got that. You're confusing me up here. All right. Please go ahead. Yes.
Thank you, Mr. Chairman, Vice Chair, and members of the committee for giving us the opportunity today to share the views of the Maryland Mortgage Bankers and Brokers Association. My name is Rich Green, and I am co-chair of our legislative committee and a past president of the Mortgage Bankers Association. Since the introduction of Senate Bill 817, the MMEBA has struggled to find a way to support a well-intended bill to promote transparency and fairness in the appraisal process for Marylanders. Unfortunately, we have not found that way. Why? Because the bill creates serious conflicts with existing federal appraisal requirements which govern lender and appraiser communications nationwide. This was born out of the financial crisis and the mortgage market meltdown back in 2008, when Dodd-Frank expressly limited communications that could influence or even appear to influence an appraiser's independent judgment. These standards are embedded in the selling guides of both Fannie Mae and Freddie Mac and are mandatory for loans sold in the secondary market to those agencies. Clearly has a firewall for communication. SB 817 establishes a state-mandated communication structure during the appraisal process that will conflict with appraiser independence, the appearance of undue influence, even the perception of noncompliance can render a loan ineligible for sale purchased by Fannie Mae or Freddie Mac, who I believe currently control about 60% of all mortgages, conventional mortgages in Maryland. Because the overwhelming majority of Maryland mortgage loans are sold and backed in the secondary market, any legislation that jeopardizes this is an existing problem for Maryland home buyers and lenders. If lenders are faced with a repurchase risk due to state-mandated appraisal requirements, we have an unintended consequence of not having mortgage financing in Maryland. So I'll conclude just by saying that there's a federal bill that takes care of this issue. With all this, and with all due respect, I wonder why we pass a bill that mirrors what we are already doing. Why conflict with federal policies that exist already and work? So we respectfully request an unfavorable report on 817.
Excellent. Thank you very much. All right. Questions from the committee? Seeing none. Thank you very much. All right. All right. So now we'll switch over to Mark. You're up. Welcome.
Good afternoon, Mr. Chair. Oh, can you hear me all right?
We can, yes, we can hear
Okay,
you.
great, thank you. My name is Mark Schiffman. I represent the Real Estate Valuation Advocacy Association. My members are appraisal management companies, and they are licensed in the state of Maryland. So we're a part of the appraisal transaction. We are actually probably more favorable with amendments than straight oppose, and it's a lot of what has been covered by the lenders today. The challenge we have is with the process being provided not or proposed not the idea of ROV. We're big fans of ROV. We were part of the PAVE task force federally. They ruled out the Tidewater Initiative as a model because it's a different set of circumstances than other lending. So Fannie Mae and Freddie Mac have had a reconsideration of value policy in place since 2024. And that policy applies to all transactions and is also triggered not only by whether an assignment meets a contract price, but it's also if a consumer or a homeowner feels that there was bias, some type of bias involved. And that's a big difference because the current bill that's been considered doesn't even include that factor. It's just really based on the fee. So what we suggest is Fannie Mae and Freddie Mac already have this in place for all of their work in Maryland and every other state. Every lender is already doing it. The question, are those loans covered by FHA and USDA? By adopting a process that is identical to what Fannie and Freddie have, you covered those as well in the event that House Bill 6644 at the federal level doesn't require a ROV policy. It doesn't pass. If it passes, language in there would require the USDA, the VA, the FHA, and the FHFA to require all mortgage lenders to have an ROV process in place. So our advocacy here is in support of what you're doing, but this bill creates really big problems for appraisal independence. At the state level, it violates state law, and at the federal level as well. So we want to work with you all and passing something that is workable for Maryland. It's consistent with what already exists and isn't a heavy lift for you all. So thank you.
Mr. Schiffman. Appreciate it. Seeing there are no questions, that ends the hearing on Senate Bill 817. Next, we're going to have Senate Bill 953.
Good afternoon. Senator Sidnor, members of the Judicial Proceedings Committee, for the record, Jordan Lewis, Legislative Director for Senator Kevin M. Harris, here to present SB 953, Charles County Rent Stabilization for Seniors on behalf of the Charles County Senate Delegation. Many older adults live on fixed incomes derived from Social Security, pensions, and limited savings. Sudden or excessive rent increases can create severe financial hardship for seniors who often have limited ability to increase their incomes or relocate. SB 953 seeks to address this issue in a targeted manner by authorizing Charles County to adopt a rent increase limit for seniors tied to the Consumer Price Index plus 3%, ensuring that rent adjustments reflect real economic conditions while protecting vulnerable residents. By linking rent increases to inflation, this bill strikes a careful balance between the need of tenants and the legitimate interests of property owners. Landlords retain the ability to adjust rents annually, while seniors gain protection from unpredictable or disproportionate increases that could threaten their housing stability. Stable housing is particularly important for older adults. Housing insecurity among seniors can lead to increased health risk, greater reliance on emergency services, and higher public costs associated with displacement and institutionalized care. Preventing displacement through reasonable rent stabilization is both humane and fiscally responsible. We recognize the importance of protecting Charles County seniors and ensuring that they can age in place. We also recognize the seriousness of Maryland's affordability and housing crisis. SB 953 advances the mission of achieving housing security for seniors and increasing affordability for the vulnerable. And for these reasons, we respectfully request a favorable committee report on SB 953.
Thank you very much. Mr. Lewis, seeing no questions, let me ask, did you have a delegation letter?
That is a great question. I imagine that that is something that will come.
Thank you very much. Oh, yes, there is a question. Senator?
I expected there'd be other favorables, but there's just the one witness. Right. Okay. So, in Montgomery County, they have rent control.
Yes.
And other than in the independent towns of Gaithersburg and Rockville, which I gather have their own separate areas and therefore are not subject to Montgomery County rent control. Okay. My understanding is that in the rest of the county, the construction of rental housing has stopped. There have been no permits issued for rental housing construction in Montgomery County since rent control was enacted.
Sure.
And we had a person come and testify before us a year ago that the reason for that is because in order to build these large projects, you need to get financing from insurance companies or other large holders of money, and they're not willing to invest their money in Montgomery County under the circumstances. Sure. Aren't you concerned that in Charles County, if we enact some form of rent control, that the same thing's going to happen? We have a state shortage of housing that everybody talks about, how we need more housing. But aren't we going to be moving backwards if we pass rent control, which would discourage the construction of additional housing?
No, I don't believe that we'll be moving backwards. This is a targeted bill. This bill is aimed directly at seniors. Seniors who are eligible to receive full Social Security retirement benefits. This is targeted. This isn't for all apartments, all residences owned by other entities in the county. This is strictly for seniors. This bill will allow them to be able to maintain their residences. We don't anticipate that it's going to prevent further development in the county. That's also what the purpose of this Consumer Price Index plus 3% is. That's to ensure that the investment can continue by allowing property owners to increase rent to account for necessary investment needed into their properties and for their residences.
And Senator, Mr. Lewis is Senator Ellis's chief of staff. So
okay.
I am Senator Harris's legislative director.
Sorry.
Wow. It's okay.
That's a distinction. Well, it's nice to have you before us.
Absolutely.
I do one more question, if I could. So it sounds like what you want is to have in the same rental facility, people living side to side, one person who is working at a particular job who is 59 years old will be paying one rent. The same person who's working at the same job who is 62 years old will be paying a different, lower rent because of the effect of this bill. Is that right?
I would say that that's an accurate assessment. The goal of this bill is to ensure that those of a certain age who are retired, receiving retirement benefits, can stay in their homes. If the person that is not receiving full retirement benefits is able to work, and well, actually, I would not agree with your assessment, because what you suggested is that somebody receiving those retirement benefits and working is somebody receiving those retirement benefits and somebody who is not receiving those retirement benefits are in the same situation, right? So if somebody is working and somebody is not working and receiving Social Security, their situations are different. Their housing situations.
I was going to say, in the bill, I saw nothing about retirement benefits. So many people, I'm 75, I'm still working.
Certainly.
A lot of people over 62 work. And many of them probably hold comparable jobs to people who are under 62.
Sure.
And probably are making about the same pay. But it sounds like what this bill would do is if you have two of those people occupying adjoining apartments, one of them is going to have a higher rent and the other is going to have a lower rent by the mere fact that the one who has the lower rent is now over 62 years of age, right?
I would say that is an accurate assessment.
Okay, great.
Yes, sir.
Thank you.
Absolutely. And also, I hear Senator James discussing the part where it's the required age to receive full Social Security benefits. That is going to be a committee amendment. That's why you're not seeing it in the bill.
And what about income?
Income?
Just a moment. I know.
I apologize, Mr. Chair. I
Yeah,
apologize.
just.
Excuse me.
All right. Would you mind? Thank you.
Sorry, somebody else.
Go ahead.
Do you?
You got two on that.
You're up.
Okay, yeah. So the only other question I had, and thank you for picking up that we didn't see the language.
yes.
Okay, but then the other question I have is, I don't see anything about income. As we are older, and many people are older and working longer, most people I know that are over 60 are still working, not getting Social Security, but putting that aside, people are all different incomes.
Sure.
This does not appear to do anything about income. So you could have a senior that maybe has a modest Social Security benefit just given their whole career, and you have others who, are at the maximum level, don't need their Social Security, have many other, the trilogy of 401ks. So what was the thinking there about not differentiating between a wealthy senior, and data shows a lot of seniors are well-to-do, and then people that are not in that circumstance?
That's a good question. What I'll say right now is that the bill and the committee, the bill and the amendment are before the committee to be considered.
Okay.
It certainly is something that's worth considering.
Good.
Perhaps, so.
Thank you.
We will.
Well, I appreciate that you answered that. You didn't get defensive. So, it was better to have a discussion about it. Thank you so very much.
Absolutely.
Thank you, Senator Folden.
Thank you, Mr. Chair. Yeah, I wanted to just say, good job coming in here.
Thank you.
And tell Senator Harris, he probably shouldn't send you any more of these. Man. He might be looking for.
Right.
No, thank you. You did a good job, man. You did a good job.
All right, thank you very much. We're next going to move to our favorable with amendments. Mr. Greenfield, I believe, is in person, and we have 2 people who are virtual. So we'll start with Mr. Greenfield. Leading edge.
Yeah, good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. Aaron Greenfield here actually on behalf of Leading Age Maryland, favorable with a very specific amendment related to subsidized housing. I'm also joined for technical questions by Diane Smith, who should be in the virtual room. Leading Age Maryland is a community of more than 150 not-for-profit aging services organizations, including affordable senior housing. I want to touch a little bit on the sponsor's testimony. The bill just says CPI. There's no amendment that I've seen that adds CPI plus 3%. I assume that's going to be an amendment that's forthcoming. Experience, at a time that the state is facing a dearth of 96,000 housing units, experience shows us that rent control policies can unintentionally discourage housing development. I caution the committee from passing any rent control bill. So let me be very clear about that. I have grave concerns about it. As Senator West mentioned, you see in Montgomery County, after Montgomery County enacted rent control in 2024, multifamily housing permits dropped 96% from an average of 582 units per quarter to just 23, suggesting that regulatory uncertainty can slow housing investment and reduce supply. For that reason, Leading Age respectfully urges the committee to adopt a targeted amendment exempting federally subsidized housing from rent control in the bill. Federally assisted housing already operates under very strict federal affordability and rent setting rules. Applying additional rent control on top of federal requirements would create duplicative regulation and operational complexity. The amendment is drafted in our written testimony, which I have submitted to the committee, and for those reasons, I respectfully request a favorable report with that amendment. Thank you.
Thank you very much. We'll go ahead virtually to Mr. Ruben Collins. And then next, Daniel Mitchell.
I'm here on behalf of Commissioner Collins. Danielle Mitchell, Acting Deputy County Administrator for Charles County Government. I'm here on behalf of Commissioner Collins. He had a conflict, so I'm here to provide testimony on his behalf and on that of the Board of Commissioners. The Board of Commissioners proposed this to the Charles County delegation after extensive public hearings and input. They've heard from the community of Charles County and the seniors in particular about the need for some control and some predictability around increases in residential rents. They've seen rent increases hundreds of dollars, and as Mr. Lewis so eloquently put, they really are not in the position to be able to absorb those kinds of changes in light of the fact that they're on a fixed income. We're favorable with amendments because there is a request from the Board of Commissioners to make the legislation enabling and to also clarify that this rent increase or cap on the increases would apply only to those residential units that are leased by a senior as opposed to occupied by a senior, which is how the original read. So I'm not sure if the committee has the version that has that change from occupied to leased, but that is the request of the Board of Commissioners. Otherwise, we fully support the legislation as being needed in Charles County for the benefit of our senior residents. Thank you.
Thank you very much. Ms. Smith, Diane Smith.
Thank you. Thank you, Chairman Smith and the members of the committee. My name is Diane Smith, and I represent CSI Support and Development Services, a nonprofit organization that develops, owns, and manages 13 affordable senior properties in Maryland, totaling 1,323 units. Nationally, we own and manage 65 properties, over 7,000 units. All properties use HUD funding, such as the Section 8 and Section 202 program, and federal subsidies, such as the Low-Income Housing Tax Credit Program, to keep rents affordable and maintain to very high standards. CSI owns an affordable housing property in Charles County, which contains 96 units with a mix of 1- and 2-bedroom units. It was developed in 2006 using the Low-Income Housing Tax Credit Program and favorable lending from the state of Maryland's Department of Housing and Community Development. To obtain the highly competitive funding, the property committed to serve seniors age 55 and older with incomes ranging from 30% to 60% of the HUD area median income. Annually, HUD issues the area median incomes for every city, county, and metro area in our country, and annually rents at affordable properties are capped at these properties based on the federal definition of affordability. Further, rent capping regulations at a federally subsidized property is not necessarily and would further complicate an already complex financial operating structure. Federally subsidized properties are designed to have very tight operating budgets with very small margins. Adding additional rent increase limitations coupled with high expense increases puts additional pressure on already stressed properties. Federally subsidized properties like our property are highly scrutinized by HUD and the IRS and the state of Maryland to ensure compliance with all state and federal affordability regulations. These properties are already the most rent-controlled properties in the market. Operating these types of properties is already rife with confusion and conflicting state federal regulations. Thank you for this opportunity to voice my concerns, and thank you for serving the state of Maryland.
Thank you very much. I see, I'm sorry. Senator, go ahead.
I do have a question, and you all can get back to me because it's just become an interesting conversation, but I think it'd be helpful to know how, what percentage of the county's housing is what you all mentioned, federally subsidized housing, and just have a little bit more of a breakdown of, you know, the seniors population, how many units are available for that particular federally subsidized group, and maybe some idea of what the community's eligibility would be. Just some food for thought there that I think, since you all are bringing up some interesting issues for us to think about.
Is that for Ms. Mitchell?
Thank you.
Is that question directed to Ms. Mitchell?
Well, I
Or,
either one. I
Okay.
think anybody that might have some information about it.
would you be able to help with that?
We can get that information for you.
Very good. Thank you. Senator?
What is the Carroll County ladies, excuse me, Charles County ladies still on the air? Or is she?
I am.
There you are. So I'm looking at a study by the National Apartment Association that's cited in the Multifamily Housing Association's opposition to this bill. And it cites statistics. I wondered if you can confirm them. They say of the multifamily properties in Charles County, and adjusted for inflation, the year-over-year market rent growth since 2020 has decreased in 4 of the last 5 years. And within the senior housing subset, inflation-adjusted rent growth has averaged a negative 0.777% per year over the past decade. Do those numbers comport with what you all have in the county?
No, but I would say I can't confirm that data. I know anecdotally what we are hearing from our residents, but truthfully, I don't know whether those numbers are accurate or not.
Okay. I will see if I can't get the Multifamily Housing Association paired with you or with somebody else from Charles County who's dealing with this issue, because it would seem to me that if in fact the rents are going down in Charles County, maybe there's just not a need for this bill. So would you be willing to sit down with them and go over these numbers to see if they're accurate?
Of course.
Thank you.
All right, so no further questions. Thank you very much.
Thank you.
Good afternoon, Mr. Chair, members of the committee. For the record, Matt Pipkin here on behalf of the Maryland Multi-Housing Association, urging a very strong unfavorable report for Senate Bill 953. You have my written testimony, 10 pages long. I apologize for that. In Charles County, we represent, by the way, 30 communities with over 5,300 units. So this issue came up last year within the Board of Commissioners. And when they were discussing the local proposal, it was our understanding that this bill that was going to come before the state would really be centered around senior housing. That is not the case, as you see. This is going to apply to all manner of properties. And so effectively what you're going to ask those property managers to treat two people who come into your office, and I'm going to treat one differently from the other based on age, which fundamentally, I mean, I have moral qualms about that. Practically, I don't know how they would do that. I mean, are we going to be conducting censuses within our apartments? You know, if two people are co-signed on the same lease, how do I, and one's older than the other, how do I determine which is supposed to apply to? And yes, to Senator West's points, I had pulled some data from COSAR. This was included in a letter that we provided to the Board of Commissioners when they were debating this. And it is true at the time, because it was pulled September 29th, 2025, that since 2020, rents have decreased 4 out of the 5 years. And within the senior subsect, again, inflation-adjusted rent growth has averaged a negative 0.77%. There's simply nothing to justify this. In fact, I went to the National Apartment Association, had them run some research for me, and found that if this were to just a rent cap apply to senior housing, you're talking about property value losses of over $11 million by 2033. It's staggering, could not urge a stronger unfavorable. Thank you.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Hugo Cantu here representing the Apartment and Office Building Association. While we represent 23 million square feet of commercial office space and 167,000 apartment units in Montgomery and Prince George's County, we do not represent Charles County. What I can say is, as you've heard, the bill, while it caps rents at CPI, we are watching the effects of rent control in Montgomery and Prince George's County right now. And we're in respectful opposition because we do understand the need to create affordability, but we're telling you that it's only going to exacerbate the problem. And to give you a timeline of what happens in a rent-controlled environment, first, multifamily permits just drop off significantly. You heard Montgomery County saw a huge drop off, and the units that rebounded, they only rebounded because they have large government subsidies behind them, propping them up. If Charles County is to see an influx of seniors moving into the county that may not want a single family, they're going to be asking for multifamily senior properties. Second, investment purchases will go down significantly, thus impacting transfer recordation taxes, and property sales in Montgomery and Prince George's County have dropped off significantly. They're at a 10-year low since the enactment. And remember, very few builders hold their assets for 30 years or more, so we're talking about the importance of a secondary market, buying the property, and then investing in that property. And that third point is financiers are looking at these long-term holders and saying, hey, we're going to provide a loan, we can do you guys are going to do the renovations, but like a home loan, the bank won't give you it if you can't do the payment. Unlike a home loan, it's not 30 years, it's 10 years. So we're talking about how important the macro and micro factors in the market are to these loans. We're asking for an unfavorable report. Thank you.
I just a question for Mr. Pipkin. So we have heard from a number of sources, including the governor in his State of the State speech, the state controller in various pronouncements, which try to explain why the state's economy continues basically to tread water rather than moving ahead, by contrast with our neighboring states, which are moving ahead rather vigorously. And the explanation is frequently that Maryland desperately needs more housing. So this bill would affect housing. So if this rent control bill were to be enacted, would you think that this would move us in the direction in which the governor and the controller want to take us, which is the construction of additional rental housing? Or do you think it's more likely to move us backwards and discourage the construction of more rental housing in Maryland?
That is an excellent question, Senator, and I would say this would firmly go against the goals and wishes of both the governor and the legislature of trying to increase the supply. I think this would have a dramatic effect, both for people just simply trying to invest and reinvest into the properties, as well as building the ones, building new ones.
Okay, thank you for your answer.
Thank you.
All right, seeing none, thank you all very much.
Thank you.
All right. With that, that'll conclude the hearing for Senate Bill 953. We'll now move on. We're going to go ahead to 871, and then we'll switch over to Senator Henson to round us out for the rest of the day. All right, members of the committee, for the record, Senator Smith here to present Senate Bill 871. This is a bill about punitive damages, and if you all may remember from law school a case from 1992 that is the gold standard. It's the touchstone case for punitive damages in Maryland, the Zenobia case. And that case essentially established three principles of how we talk about and how we award punitive damages in Maryland. One, first, it said that the courts abolished the longstanding standard that punitive damages had to be something that was a consequence of action that arose out of contract. That was a test for punitive damages. Second, it rejected the implied malice standard and instilled what we have under today, which is the actual malice standard for conduct that has to take place to award punitive damages. And then third, it established that you have to prove that actual malice by clear and convincing standard. So that is the regime that we've operated under in Maryland to award punitive damages since 1992. Many of you who have gone to law school in Maryland probably had that in your torts class. I went to school in Virginia, so I wasn't as familiar with the Zenobia case until I came here to the Judicial Proceedings Committee. But punitive damages, as you know, they can be assessed against a defendant for losing a lawsuit, but unlike compensatory damages, which are intended to make a plaintiff whole for the harms caused by a defendant, punitive damages are designed to punish and deter harmful conduct. Under Maryland case law, as we just discussed, courts will not award punitive damages against a defendant unless the defendant is found liable for negligence, unless the plaintiff can prove actual malice, meaning evil motive, intent to injure, ill will, or fraud. The actual malice standard, I contend, is too high of a standard It's out of line with the law in other states, and it makes it too difficult to punish wrongdoing that falls just short of criminal conduct. Currently, our law also fails to recognize that punitive damages, which are not meant to benefit or compensate a plaintiff, can be used to promote social welfare in our state by contributing funds to a still critical state program. So that's what the bill does. So the bill before you does two major things. One, it replaces the actual malice standard for awarding punitive damages in negligence cases with the gross negligence standard. Gross negligence is defined as a disregard for the rights or safety of others, including the public at large, that the actor knows or should have known is likely to cause harm and is characterized by a failure to exercise even slight care. It's willful or wanton or outrageous misconduct, a pattern of repeated misconduct. It's malicious, oppressive, or fraudulent, or can be awarded for fraudulent intent. And the definition goes on. And then second, the bill directs the state court administrator to assess, and there's an amendment that's going to be in your packet, a tax on the punitive damage award. So it specifies that that tax is going to be taken off of the award of punitive damages. The initial bill has it as a surcharge, which means above and beyond what was awarded through the punitive damages. So that's an amendment that's forthcoming. I think one of our panelists will discuss that. Again, I'll point back to how we've long dealt with punitive damages since that 1992 case. In 2017, the Maryland General Assembly actually established a task force or work group on punitive damages and wrestled with the issue of that actual malice standard and determined that Maryland was an extreme outlier in that regard. North Dakota is the only other state that requires proof of express malice. Most states do not require bad intent. They use various formulations of the rule that presumes ill will or permits a lesser showing of culpability. Many states allow punitive damages on the proof of implied malice, deliberate conduct that is so outrageous that malice is implied. So it's 7 or 8 states do that. Other states allow for punitive damages if the defendant acts in a way that is likely to cause harm and is consciously aware of or should or could be aware of the likelihood of harm. And that's the majority of the other states. Punitive damages should be available to punish wrongdoing that arises above the level of ordinary negligence without necessarily proving bad intent, as would be required by a criminal prosecution. The availability of punitive damages is especially important with regard to businesses, which are difficult to punish through criminal prosecution, but are amenable to punishment through, and their activities can be changed through actual awarding of punitive damages. So as a public policy, this is an important step for us to take. Adopting the gross negligence standard will ensure that punitive damages are actually available to hold wrongdoers accountable and to deter this misconduct in the future, or potential misconduct in the future. We've talked a lot about vignettes, and I'm sure you'll hear them from my panelists, but there was one case that I was talking about with a couple friends just last night, which was the St. Joseph Michael Medical Center, in which a doctor put in a number of stints and a number of patients over a course of time that were, I mean, it was done in a grossly negligent manner, did not arise, it was not actual malice, did not rise to that level of actual malice, and those plaintiffs would be unable to recover under our current regime, even though it was done in a grossly negligent manner and did irreparable harm to some of these patients. In addition to eliminating the overly stringent actual malice standard, this bill joins a group of other states which have recognized that punitive damages awards can contribute to funds of other critical state programs, as this bill does. So the money that would be taxed off of the award goes to the blueprint under this bill. But Alaska, Georgia, Illinois, Indiana, Iowa, Missouri, Oregon, Pennsylvania, and Utah all have set up similar schemes to award, to take off of a tax off of the award to fund critical state programs. So with that, in the interest of public safety, in the interest of civil justice, in an interest of holding wrongdoers accountable who are unable to reach that actual malice standard, we believe this is the right policy for us to move forward, as Maryland is an outlier, an extreme outlier, and was elucidated through that 2017 report. We should move forward with the gross negligence standard and take a portion of those awards to go to financing something that this body has deemed to be a critical public policy, which is the blueprint And so with that, Mr. Chairman and members of the committee, I will pause, give to my panel, and ask for a favorable committee report.
Thank you. Thank you, Mr. Chair. Thank you, Chair and members of this committee. My name is Bruce Plaxton. I'm a former president of the Maryland Association for Justice, and I'm currently president of the American Association for Justice, and I travel the country weekly to other states and see that their tort system works efficiently, and that this bill will not make Maryland an outlier. In fact, this bill will bring Maryland in line with other states. I read the opposition that suggests that gross negligence is a low standard. Gross negligence is already the standard we use in Maryland to define vehicular manslaughter, and we send people to jail for up to 10 years for gross negligence, but yet the same victims in those cases cannot get punitive damages. The second thing that our opponents like to talk about in almost every tort bill, which never happens, is the henny penny defense. The sky will not fall if you pass this bill. And I know that because I did not study Zenobia in law school. I practiced in Maryland for 10 years before the Zenobia decision, and there was no outcry to do away with punitive damages. Punitive damages was hardly ever pled. It was not something that we saw a lot in personal injury cases. Only the most gross, outrageous conduct would be eligible, and it wouldn't even get to the jury. When our opponents say every case will involve punitive damages, that's not true. We have judges that must decide that there is evidence of outrageous conduct and gross negligence before the jury even hears about punitive damages. And if the jury were to award punitive damages, we have safeguards in the case of remittitor, or the judge can take away the punitive damages award if this standard has not been met. What we've heard, and I'm going to read the definition of gross negligence, is our opponents have said that people should not be held to this low standard. Well, gross negligence is defined as a failure to exercise even slight care, willful, wanton, or outrageous misconduct, a pattern of repeated misconduct, malicious, oppressive, or fraudulent intent, acts or omissions that create a high degree of risk to others, and conduct that demonstrates indifference to legal obligations or the consequences of misconduct. I would suggest that the very people that engage in that type of conduct should be responsible to pay punitive damages in Maryland like most of the country.
Thank you.
Thank you, and I urge a favorable report.
Mr. Toll, you're marked down as favorable with amendment?
I am favorable with an amendment. I'm here to explain the amendments that are on the bill and to urge their adoption.
Before we go to you, since this
Very
is
well.
all of the favorables, any questions from anyone? Senator?
Yes, thank you, Mr. Chair. I do have a question, and it relates to part of the bill that really was hardly discussed, which is this surcharge. So, Mr. Plaxton, maybe you...
That's a subject of the amendment, so let me address the question if I can.
It's really a tax now, not a surcharge.
Mr. Chair, would you want him to just testify?
All right, I'll let...
No, I'm just asking, would you want him to testify?
Thank you for the
amendment?
So yes, thank you very much.
I'm just reading the bill, so tell me about it.
I did talk about it a little bit, but we're changing it to would be a tax on the actual award, not a surcharge, but that's what the amendments actually speak to. So you will hear an answer to your question through this testimony.
Okay. Well, Mr. Plaxton, do you support the bill as written with the surcharge?
I am also favorable with amendment. I think that the amendment that the Maryland Association for Justice is proposing is better, but the bill as is, we would be favorable for. The bill that we're amending actually would require the grossly negligent tortfeasor to pay less.
So why don't you sit down? We're going I think I'm going to be quiet, and we'll let Mr. Tolley present the amendment, and then once I understand what the amendment is, I can ask questions.
Sounds good. Thank you.
Thank you. Thank you, Mr. Chairman, for this opportunity to address the committee. Thank you very much, members of the Judicial Proceedings Committee, for this opportunity to testify in support of Senate Bill 871 with amendments. The purpose of punitive damages is primarily to deter outrageous conduct that recklessly disregards human life. That is a standard, as Mr. Plaxton mentioned, that already is used in the context of the criminal law to deter reckless driving, drunk driving 90 miles an hour on a rural road that might kill a person, we could put that person in jail with an enhanced penalty. The problem that sometimes arises is that sometimes corporations act with reckless disregard for human life, and you can't put a corporation in jail. There's no criminal counterpart to punitive damages. So when social media accounts target teenage girls who delete a selfie by providing them with content directed at beauty, self-image, anorexia, and self-harm, there's no punitive damages available in Maryland to deter that conduct. There is in almost every other state, but not Maryland. So Maryland is left, as the dissent in Zenobia said, and I know I'm going to get to my amendments in a second, but the dissent said permitting punitive damages when one acts with actual malice, but not when, given the totality of the circumstances, the same person acts in total disregard for the safety of others, has no reasoned basis. 5 judges of what we used to call the Court of Appeals decided to get rid of the gross negligence or implied malice standard in favor of actual malice. And we submit that essentially eliminated the deterrent effect for anything above negligence. The amendments, I'm sorry. I'm happy to answer a question about the amendments.
Here's my question. First question, Mr. Tully. Now, would you please explain your proposed amendment?
Yes, of course. So the bill as drafted and proposed in its original form here is taken from a bill that was amended in the House Judiciary Committee last year to add a surcharge. There was a misunderstanding as to what punitive damages were for, and so the surcharge was added. What the amendment does is it takes out everything from page 2, line 17 through page 3, line 11, I believe, and replaces it with a scheme that's based on Oregon law, where the punitive damages award, assuming, again, under the supervision of a trial judge, there is sufficient evidence to satisfy the clear and convincing standard, that's the enhanced burden of proof for punitive damages in Maryland, that there was, on the part of the defendant, a knowing disregard for human life or a conscious disregard for the rights and safety of the public, the gross negligence standard that foreseeably would result in harm or death, that upon the verdict, including an award of punitive damages, the punitive damages award would be shared half by the prevailing party or parties and half by the state. And the reasoning behind that is that what we're talking about really is a public fine for this outrageous, reprehensible conduct. And the prevailing parties, by identifying the conduct and bringing it to light in the litigation, shares in the fine with the state.
Okay.
And it is a 50-50. The state would have, under the amendment, a status as a creditor, a judgment creditor, upon entry of a judgment on the verdict, so that the state's interest in that portion of the punitive damages can't be negotiated away by the prevailing party and the defendant.
Okay, so there's...
At least not without notice to the state.
So that then triggers my question. So all along, punitive damages, as I've understood them ever since law school, are intended to deter conduct here in Maryland under Zenobia, which occurred with malice. So we want to stop people from doing this kind of stuff in Maryland. And the damages are, the jury is asked to award damages to deter this kind of conduct in the future with malice. And the damages go to the person who was injured, not to the state. So if you change this either in accordance with the bill, which is a surcharge, which would then go to fund the blueprint, or as you're suggesting, half of the punitive damages are going to go to the state, and the jury, of course, is going to know this.
No.
Well, of course they will.
I think there's language in here that the jury would be instructed not that the money going to the state
I don't
isn't
see
part
that,
of
but
it.
it's going to be in the newspapers.
could be
It's
left
hard to
out.
keep this information from people because there'll be stories about punitive damages and that half the money is going to go to the state to fund the blueprint, which is going to educate your children. Now we're moving this from punitive damages intended to deter rather to telling and effectively asking the jury to vote for large awards, the money from which is going to go to pay for school education of your kids or whatever. So if you enter a large punitive damage award against a corporation, that corporation is going to pay and your kids are going to benefit. It totally changes, does it not, the whole premise of punitive damages?
So I would disagree, and I apologize before for interrupting you. It wasn't my intention. I disagree because it's easy to amend the bill, and I'm not the senator, but I have no problem with a rule that the jury is not instructed or shall not be informed, just the way we do with the cap on non-economic damages, right? We don't tell the jury about the cap on non-economic damages. We don't have to tell the jury about what happens with the punitive damages award. Punitive damages awards can be very, very large. There's no question about that. When you're talking about a multi-billion-dollar international corporation like Hyatt, to take an example from Missouri, where recently they had a convicted sex offender with a long list, a long rap sheet of sexual assaults, and the Hyatt Hotel in St. Louis put that person in charge of security and gave him a master key to everyone's room. And so predictably, when a woman was sexually assaulted on a business trip in that hotel, and it went all the way up in the court system in Missouri, and every judge said, yes, that $150 million punitive damages award is appropriate and consistent with the law, because in a multi-billion-dollar defendant, it needs to be it can't be $5, that's a rounding error. It has to be a substantial deterrence to a multi-billion-dollar corporation to make them change their minds. Now, does the plaintiff get the $150 million? I don't think so. Now, the average punitive damages award is obviously nowhere near that. It's more like $30 or $40 or $50,000 nationwide, depending on what your data source is. But it makes sense that the money should be split between the prevailing party and the state, in part because it could be a very, very large amount of money. And secondly, it's a public fine. The purpose of deterrence is a public purpose. The purpose of preventing this from happening in the future is a public safety purpose. And so why shouldn't the state be part of that?
Okay, let me just push back a little bit.
Of course.
I believe in, as much as possible, being transparent and full disclosure and fully informing people what you're doing and why you're doing it, and so that they know what the effects of what they do are going to be. The idea that everybody in this room that's heard this conversation is going to know that half the money is going to go to the state to fund the blueprint. And anybody who reads the newspapers carefully will know that. But the average person won't know it, and we don't want them to know it because we don't want them to be on the jury knowing that. And we don't want them when they're back in the jury room saying, hey, this money, a lot of this is going to go to educate my kids. And hoping that not one person on the jury is aware of that, and that one person won't inform the other jurors where the money. That goes against my grain. You see what I'm saying?
I do see what you're saying, but I think the answer to that is the answer that we have in every case, right? I try cases for a living, and I'm on the jury instruction committee for the Maryland State Bar Association on the civil side. And there are jury instructions where the jury is instructed that they must follow the law, and they must follow the law as the judge informs them. And the judge's instructions, it's easy to predict, the judge's instructions will not include anything about, and could even include a line that it's not important for you to or even to consider what happens to the verdict. Jurors are not told about the cap, they're not told about remitter, they're not told about a lot of things that happen after trial is over and the verdict is returned. And so while there may be speculation in the jury room, there is an instruction that their verdict shall not be based on speculation, but only on the evidence before them.
Okay, great. Appreciate this dialogue. Thank you.
Of course. Thank you for the questions.
All right, then.
ends our questions. Thank you very much. Next, we'll move to the unfavorables. So, Mr. Hinton, Mr. Silverman, Mr. Wise, and Mr. Whitaker. I'll call the rest of you up later. I'm only calling the four since it's only got 4 seats. I thought we had 4 seats.
Mr. Chairman and members of the committee, Carville Collins here on behalf of Maryland Employers for Civil Justice Reform Coalition. We're here in opposition to this bill. You've heard from the proponents that the bill is, that the current law makes Maryland an outlier, that we have sort of an extreme or an excessively high standard. With all due respect to our bill sponsor, let me set the record straight here. The reality is that Maryland's approach reflects a careful choice made by our highest court. After seeing firsthand what happens when punitive damages are expanded too far. In the 20 years when Maryland allowed punitive damages based on vague concepts like gross negligence, the courts, this is not me, the found that verdicts became inconsistent and unpredictable. Businesses and individuals could not reasonably know what conduct would trigger punishment, and juries were left without clear guidance. The Court of Appeals further found a literal explosion of punitive damage awards. It's for these reasons that the High Court restored the actual malice standard more than 3 decades ago, and why it has been applied consistently ever since. The proposed change in the bill would roll back that settled law and replace it with a contrived definition of gross negligence. But it's not the old gross negligence that we used to have before 1992. It's so broad that nearly any accident could qualify for punitive damages. Failing to exercise even slight care. That phrase and the other phrases on page 2 of the bill are not the gross negligence standard. Those phrases are so elastic that they would turn ordinary negligence cases into high-stakes punishment cases. For these reasons, Mr. Chairman and members of the committee, we urge an unfavorable report. Thank you.
Thank you.
Mr. Chairman, members of the committee, Robert Etten on behalf of the American Property Casualty Insurers Association, and I think to no one's surprise, we are in opposition, with all due respect to the chair, and to his bill. You know, it's interesting. You have our written testimony, which outlines kind of the history of this issue, discusses what the impact would be on Maryland businesses, on Maryland citizens, and their insurance rates. And keep in mind that adopting a gross negligence standard means that when you get sued or your business gets sued, it's probably going to be covered under your insurance policy, whereas actual malice, quite frankly, might not be covered. Notwithstanding that, when you look at the key case in all of this, which is the case, as Mr. Collins stated, goes back to 1992. So what's that, 34 years ago? That case goes back to. In that case, the court said clearly and unequivocally in a 61-page discussion that, and I quote, "Therefore, we overrule Smith v. Gray," that was the previous case, "in a non-intentional tort action, the trier of facts may not award punitive damages unless the plaintiff has established that the defendant's conduct was characterized by evil motive, intent to injure, ill will, or fraud, i.e. actual malice." And please keep in mind, there is no cap whatsoever on the punitive damages, none. So we know we have a cap, and you've heard the bill. We have a cap on non-economic damages. We know that.
Thank you, Mr. N.
But for punitive damages, there is no cap. So they can award any sum they want.
Thank you, Mr. N.
And depending on the facts, depending on, what they hear, it can be tens of millions of dollars.
Thank
so
you, Mr.
therefore,
N.
I appreciate you letting me ramble on.
Yes, you
we're
are.
Very much opposed. The chair would have cut me right off. We're very much opposed. Thank you.
Thank you, Mr. N.
Mr. Chairman and members of the committee, thank you for the opportunity to testify today. My name is Carrie Silverman. I'm here today on behalf of the American Tort Reform Association to respectfully oppose this bill. As you understand, punitive damages are intended to punish and to deter truly reprehensible conduct. Maryland law has stayed true to that purpose. The Maryland Supreme Court has reserved punitive damages for malicious, evil, intentional misconduct, and fraud. They are not intended to punish carelessness. They're not intended to fund our schools or close budget gaps. Some states over time have relaxed their standards for punitive damages, and Maryland, as you heard, did so for a 20-year period, and the Maryland Supreme Court then reversed course. Why? Because lowering the standard led punitive damages, or the threat of punitive damages, in virtually every case, in cases involving no more than mere negligence, or as the Maryland Supreme Court called the gross negligence standard then, which was higher than what's in this bill, big negligence. So what happened? The U.S. Supreme Court declared punitive damages had run wild and began to strike down awards as extraordinary and violating due process. Half of states, not including Maryland, those that had lowered their standard and had problems, adopted caps to control punitive damages and provide some predictability and some proportionality. Maryland retains an appropriate high standard, but when awarded, there is no cap. And as my written testimony shows, there are a number of states that have similar high levels that they've retained, New York, D.C., Maine, for example. The bill, however, has this six-pronged gross negligence standard that would allow punitive damages or the threat of them in every case. Maryland also should not rely on punitive damages to fund the state budget or our schools. It should not have a financial interest in having more or larger punitive damage awards, and jurors shouldn't have, as Senator West indicated, in the back of their mind when they go in the deliberation room, that punitive damage could be funding their state's budgets and programs. I welcome your questions.
Mr. Wise.
Good afternoon, Mr. Chairman and members of the committee. I'm Steve Wise here today on behalf of MedChi, the State Medical Society, the College of Emergency Physicians, and the Family Physicians. Our concern with the bill is that while typically medical malpractice cases today do not give rise to an award of punitive damages, that the new definition in the bill could easily sweep them into most medical malpractice cases. Particularly that language, acts or omissions that create a high degree of risk or harm to others, but there's other portions of it as well. What would happen if we made that change here in Maryland? And I think, again, the court got into this in the Zenobia case, but I'll read you one sentence, and this is the fear of the medical community. To sanction punitive damages solely upon the basis of conduct characterized as heedless disregard of the consequences would be to allow virtually limitless imposition of punitive damages. So again, what happens if we go to a world where punitive damages are pled regularly and brought before a jury? I was, in researching this, looking at states with anything going on in this area at the present time, and stumbled across the state of New Mexico, which has not exactly, but very similar standard to what is proposed here under their current law. And they are debating this issue in their current legislative session because they have found that punitive damages are being pled in every case, partly for purposes of leverage, so that they can force physicians into settlements. The problem that was mentioned earlier is that in some places, punitive damages are not covered by medical malpractice policies. What I've discovered is you could potentially get an add-on policy to cover them. But the bottom line is, if they're present in every case, physicians recognize that, they fear for their personal assets, and they make decisions accordingly. Thank you.
Great. Thank you, Mr. Chair and members of the committee. I'm Jake Whitaker, and here on behalf of Maryland's hospitals and health systems in very respectful opposition to Senate Bill 871. So I won't repeat what the other panelists said here today, although we are in very much full agreement. But I thought I'd take the time to really talk about how this bill specifically impacts Maryland's hospitals. So I just want to let this committee know that Maryland's hospitals operate under a unique payment model. So that means kind of two things. One, every single acute care hospital here in Maryland is a nonprofit, and we operate also under fixed revenue. So that means we can't raise prices, we can't have new lines of service to increase the revenue to cover new costs like punitive damages. And so for us, it's really just a zero-sum game. So every single dollar that we spend on extra damages is dollars that we can't spend at direct care at the bedside or hiring new nurses or addressing ED wait times. And I think it's more than just the financial constraints, and more importantly, it's really just a workforce issue and an access to care issue for Maryland's hospitals. So if our liability environment, which is already very challenging, gets any worse, Maryland could become a more undesirable place to practice medicine. So that makes it already harder to compete with other states to hire the best medical talent to serve our hospitals. And really, it just makes it a challenge to, with some of the other financial constraints, to find those physicians. And frankly, we just feel like it's kind of adding insult to injury. Right now, hospitals are losing more than $600 billion in federal Medicaid cuts or Medicare cuts, and this is just on top of all that. And so because every dollar that goes to punitive damages is a dollar that we have to take away from direct care to patients, we're in very respectful opposition to Senate Bill 871. Thank you.
Thank you. We have two other testimony for unfavorable, but I believe we can ask questions of this panel if there are any. Seeing none, thank you very much. Next, Mr. Joseph Johnston and Lauren Pockman.
Okay, good afternoon. My name is Joe Johnston. I'm here on behalf of Maryland Defense Counsel, and we oppose Senate Bill 871. Under present Maryland law, punitive damages are awarded to punish a defendant whose conduct is characterized by evil motive, intent to injure, or fraud. It's a very clear legal standard. If you punch someone in the face, you can get sued for punitive damages. If you commit fraud, you can get sued for punitive damages. The policy behind this standard is punishment and deterrence. We don't want people to act with evil motive, with intent to injure, or we don't want people to commit fraud. That's why punitive damages are uncapped. This bill would lower the standard from actual malice to gross negligence, and we oppose this bill for two primary reasons. First of all, as has already been discussed, this bill will lead to an increase of punitive damages litigation in Maryland, both in personal injury cases and in medical malpractice cases. Second of all, this bill will make it more expensive for small businesses and for hospitals to defend against personal injury cases and medical malpractice cases, and to settle cases. And the chairman mentioned, he brought up the case of Mark Madej. Dr. Madej, in that case, there was a $37 million payment for the alleged conduct in that case. He lost his medical license, and he is now deceased. With respect to physicians, I can tell you from years and years and years of defending physicians against medical malpractice, they don't need added deterrence with respect to gross negligence. Physicians spend years and years to get their license, and the mere threat of losing their license for potentially grossly negligent conduct is enough of a deterrence. Their reputation and their license means everything to them. They do not need an additional claim of punitive damages for deterrence. So respectfully, it would go overboard to allow punitive damages cases for gross negligence in medical malpractice cases. Thank you.
Good afternoon, Mr. Chair and members of the committee. Thank you for the opportunity to testify in opposition to SB 871. I just want to preface my comments by saying that I have not seen any of the amendments that were discussed at length by the favorable with amendments panel. And honestly, having heard that discussion, I have a number of questions myself about what they actually say. So I'm going to try to focus my testimony on things that are applicable broadly without regard to what may be changing in the bill as we speak. And I apologize in advance if I am referring to parts of the bill that no longer exist. I think as you've heard from the prior witnesses, parties are only eligible for punitive damages once compensatory damages or actual damages have been awarded. And those include economic damages like, damages for actual medical bills or, loss of wages, for example, or non-economic damages like pain and suffering and loss of consortium of a spouse and things like that. Punitive damages are separate from both economic and non-economic damages, and they're meant to punish defendants and deter future bad behavior. They're meant to be proportional to the degree of defendant wrongdoing and are not meant to bankrupt a defendant. That said, imposing a surcharge or a tax, whatever you want to call it, of 50%, would potentially compromise both the proportionality and of the punishment and the solvency of the defendant on whom it's imposed, particularly if the jury is not permitted to know that the surcharge or tax is being imposed. Combining the 50% surcharge with the lowered standard would allow for the awarding of punitive damages that would prohibitively increase the cost of doing business in Maryland, especially for small business and nonprofits, as you heard previous witnesses say. The fiscal note also indicates that the bill would increase state and local expenditures, especially for entities like the Maryland Transit Authority, for example, which unlike most other state agencies doesn't enjoy the protection of the Maryland Tort Claims Act. In summary, I'll just ask again respectfully for an unfavorable report on the bill. Thank you.
Thank you. No questions. If I might ask one thing, and it kind of connects to what you were saying and what Mr. Collins has said earlier when he was talking about Zenobia and the court kind of bringing things back at some sort of level. I'm curious, do you think that it's in the province of this body to be setting what punitive damages should be, or the court?
In general, I think it is the province of the court to take that sort of action. I mean, the current standard comes from Zenobia, which is a court case, not a previously passed statute. So right. I do see the value in sort of keeping the legislature apart from those kinds of decisions.
Okay. Thank you.
Thank you.
There are no more witnesses, so this ends the testimony on Senate Bill 871. Next, we're going to move to Senate Bill 941.
Thank you, Mr. Chairman. I believe there are 2 witnesses in favor that are here. Or 1, maybe?
It's Tanya Chestnut and then Zephyr Shaw who signed up.
Yes.
I did see Zephyr here early. Oh, there he is. And I have not seen Tanya, but if...
Oh, I think Tanya could not make it. Are you? I'll do for you. Okay. Would you allow a substitute? Ms. Chestnut could not make it. I appreciate it. Thank you, Mr. Chairman. Colleagues, for the record, Shanika Henson here to present Senate Bill 941, Department of Housing and Community Development Severe Health and Safety Risk Plan Intervention Plan. This is a bill that I believe is a really common sense bill. It would task our Department of Housing and Community Development to work with our Maryland Attorney General's office to come up with a plan for chronic bad acting landlords. I thought that I would be able to stand before you today and say, that's such a common sense thing that there's no opposition testimony. I thought if ever there were a landlord-tenant bill that didn't have opposition, it would be a bill that would be one that was supposed to come up with a plan and one that was targeting our most severe and persistent landlords that were not following the rules that we set in place. But we do have one letter of opposition. I do think, though, that the letter of opposition did a great job at characterizing some of the bill's intent, and so I'll read a little bit from the letter of opposition. But I do want to make sure that I clarify some of the things that were raised in it because I don't want anyone to have a misunderstanding of the intent of the bill. The letter states that from our lens, Senate Bill 941 TAS OLTA, and OLTA is the Office of Landlord and Tenant Affairs. That office is within the Department of Housing and Community Development. We did create that office in prior legislation. From our lens, Senate Bill 941 tasks OLTA and the Attorney General to build an entirely new bureaucracy to identify the very properties that local jurisdictions already flag for predatory landlord practices. And I'm using the air quotes that are quotes on the page. It imposes a menu of duplicative sanctions, fines, investigative costs, recovery, mandatory tenant escrow, repair timelines, mandatory relocation plans, and more. This duplicity invites a new layer of conflicting standards, dueling penalties, and more litigation, making it that much more difficult for landlords to navigate compliance standards. Local code enforcement offices already have the duty and the tools, civil penalties, criminal citations, receivership, license revocations, where conditions are truly dangerous, and emergency condemnations necessary to compel immediate remediation and health and safety violations. At the same time, Maryland's decades-old rent escrow laws found in Real Property Section 8-211 give every tenant a clear, expedited court remedy. Rent is placed in escrow until a judge is satisfied that violations have been cured. These two systems, one driven by trained inspectors and the other by tenants themselves, have proven sufficient to identify and correct severe health and safety risk properties without adding a new state layer. I thought that was a very great way to explain the current system that's in place, and I thought it was a very great way to explain the reason why the bill is before you. That's because we do have two systems that are in place, but time after time, you have systems that have not met the needs of tenants that are in the state of Maryland, and what the bill targets is the landlords who have not followed and remained in compliance with those rules. It is only those landlords that are not reached by both of those processes that would be the subject of the bill that is before you. One of the things that the process or that the opposition raised some concerns about is that landlords would be stuck in a duplicative process where they would have civil penalties that were levied by a code enforcement office and they would have some other sort of remedy that was brought to them by the Attorney General. That certainly would not be the subject of any action plan that was the result of this bill. The civil penalties that might come out of any sort of code enforcement action are not the sort of things that would be the subject of an action plan from the AG's office. Those are two different and discrete functions. The AG's office has more of a consumer protection lens where they are looking at things like, are you having fair practices? Are you in compliance with the rules of the road that are in your local jurisdiction? Not looking to enforce local code practices. When you look at the landlord-tenant code and the remedies that are available to the individual tenant, certainly the bill as drafted doesn't want to get the AG involved with making sure that local landlord-tenant law is followed. We have done a great job at providing access to counsel and making sure that tenants have attorneys that can help them do just that. What this bill does is it would have the Office of the Attorney General and DHCD identify severe health and safety risk properties. And those are defined in the bill as those properties which have been identified as having chronic and repeat violations of the types of rules that were just identified in the letter that was drafted in the testimony. The types of properties where code enforcement has been summoned by tenants. The types of properties where code enforcement has has issued violations, where they have issued local municipal fines, where they have issued local municipal penalties, and still the landlords won't relent and won't make sure those properties are brought up to code. It would be the types of properties where tenants have gone to court on a rent escrow, and still the landlords have failed to make the necessary repairs. One of the things that can happen in a rent escrow is if the landlord won't make the repairs, the court can simply terminate the lease. What I've seen happen is sometimes the court will terminate the lease and those properties will be back on the rental market within days. A new coat of paint will be slapped on the walls, and a new tenant who has no idea that underneath that coat of paint is a layer of mold, has no idea that behind those walls are leaking pipes, has no idea that in those cabinets are an infestation of all sorts of insects, rodents, has no idea that these are chronic and persistent issues, but landlords are able to turn the properties over. So this legislation is designed at making sure that even though we have two systems that are able to get in when it's an action that's happening in the moment for a specific tenant, but when we have those chronic bad acting landlords, that there's a process designed to keep track of that information and to have a process designed to say when it rises to the level of needing oversight from a consumer protection standpoint that we have that. And it wouldn't be uncommon to have a system in place where you have an ability to escalate something when the behavior is persistent and it's not being brought into compliance. So what it would do is it will put in place when there is a landlord that fails to mitigate their behavior and it is predatory, non-compliant, and negligent, a process where the OAG would be able to identify it and then have an intervention plan. The intervention plan that the bill tasks them with doing would have them come up with some steps that they will put in place with the Office of Landlord and Tenant Affairs. The bill does not require prescriptive behavior, simply the adoption of a plan. So I did see in the written testimony that was in opposition, I think there was some confusion that perhaps it would require them to take specific action. No actions required in the bill other than the adoption of a plan. We do give them until August 31st, 2027 to create the plan with the hope that they will come back to us with some ideas on how we can finally hold these landlords accountable. Because if your office is like mine, you certainly hear from your constituents who live in these chronic rental properties, and you certainly want to be able to return to them with some solutions on how we can solve some of these challenges that prevail. So that is the sum and substance of the bill. It is a bill that requires these two agencies to get together and to come up with an action plan so that we can take a look at it and hopefully come back to the table with some other policies. And maybe after they take a look at it, they'll come to the table and won't even need a bill to be able to decide how to use their collective resources to bring some greater opportunities for tenants who are living in these properties. With that, Mr. Chairman, I will ask for a favorable report on Senate Bill 941 and turn it over to the panel. Thank you.
Hey, good afternoon, Chair Smith and members of the committee. Zephyr Shaw from Maryland Legal Aid. We urge a favorable report on Senate Bill 941. As you all know, you did the hard work in 2024, passing the Tenant Safety Act. Maryland Legal Aid and other practitioners have been hard at work since that bill became effective to bring cases seeking systemic repair and remediation of multifamily properties on behalf of just dozens and dozens of clients in these Tenant Safety Act cases. What's been instructive for my attorneys has been that in a Tenant Safety Act case, we're leveraging an important tool and bringing to bear through the court system that there are these chronic, systemically deferred maintenance, unrepaired properties. But at the culmination of one of those cases, there is often little that the defendant can do when they do not have access to funding to repair the property. So I bring this up as an example where a state intervention plan would have been very important to have in one of our Tenant Safety Act cases, where our clients did not have heat through the winter. We had alerted the local housing agency that we needed the agency to work with the defendant landlord to access weatherization funds. We had to seek DHCD's interest in that case. All along, the tenants in an emergency situation. And we found that those funds for weatherization that could have brought a systemic repair of the HVAC system would have taken 3 years to implement. And that's because the agencies are not coordinated, the local, the state, the landlords. This intervention plan can really bring into alignment a lot of different interests and create a really effective solutions that are not punitive to landlords and benefit tenants. So we urge a favorable report.
Good afternoon, members of the committee. My name is Erika Puentes. I am the legislative coordinator for Progressive Maryland, and I'm filling in for Tania Chestnut. She is the president of the Progressive Maryland Enclave Tenant Association. Progressive Maryland is a statewide member-led advocacy organization promoting racial, economic, social, and housing justice. A robust part of our membership is organized into various tenant associations across the state, and we have one in Prince George's County and a few in Montgomery County as well. Our dedication to housing justice, fairness, and equity leads Progressive Maryland to support SB 941. Progressive Maryland members and tenants frequently talk about their experiences dealing with substandard housing conditions due to negligent landlords. Despite multiple county-level interventions, many of the buildings organized by Progressive Maryland tenant associations, including the Enclave in Montgomery County, have seen little to no improvement. Landlords continue to exercise unchecked power, neglecting essential maintenance and repairs. The Enclave is a key example, as it has been on Montgomery County's troubled property list and has not even submitted its last required corrective action plan. Meanwhile, tenants continue to deal with extreme rodent pests and mold infestations, chronic infrastructure issues, and compromised living conditions, including recurrent hot water outages, ceiling leaks, and malfunctioning elevators. These issues are so pervasive that Enclave Tenant Association members have coined the term housing injustice PTSD, the exhaustion from futile complaints and unaddressed issues. The state must be granted the power to intervene to support tenants. We encourage the Maryland General Assembly to put tenants over landlord profits and advance bills that ensure better housing conditions for Maryland residents. We urge the Judicial Proceedings Committee to issue a favorable report on SB 941. Thank you for your time.
Thank you very much, Senator West.
Thank you, Mr. Chair. For the sponsor of the bill, if I could talk to you for just a moment. I'm looking at the Attorney General's letter of information, and one paragraph jumped out at me that I want to read to you and then ask you about briefly. They say, the Attorney General says, housing code standards and associated enforcement authority in Maryland are administered at the local level. Each of Maryland's counties and municipalities has adopted its own housing code with its own inspection, infrastructure, violation standards, and time schedules, and fine schedules, not time, fine schedules. This localized structure means there is significant variation in housing standards and enforcement capacity across the state. Any plan developed under this bill that contemplates statewide fine structures or centralized enforcement, trying to turn the page here, would need to carefully account for this existing framework to avoid conflict or duplication with local authority. The OAG would encourage the study to examine how a state-level intervention plan can complement rather than supplant the work of local court enforcement agencies. So have you considered this paragraph in preparing for this bill, and would you be willing to propose an amendment to the bill to implement the suggestions the Attorney General makes in this paragraph?
I think the latter half of the paragraph more so expressed the intent of the bill than the beginning of the paragraph that you read. The Attorney General is a driver of the plan that would be adopted in this bill. It's the Office of Attorney General and the Office of Landlord Tenant Affairs and Department of Housing and Community Development. So they wouldn't write a plan that would be contrary to what they're able to do or what's manageable for them to do. And speaking with the cross-file on this bill, I know she put in a great deal of work with the AG's office to bring them to the table to try to get them to be a partner in it. So I'm not sure why the letter was drafted in the way that it was, but certainly what they discussed in terms of collaboration, making sure that anything that the Attorney General does by way of involvement is complementary to what happens at the local level. What we envision is that after the local levels are exhausted, similar to what we do with administrative remedies, you have to exhaust your administrative remedies and then you take a case to circuit court. We kind of envision a process like that, where you've gone through the code enforcement process, and then after you've had violation after violation, you've not corrected the bad action, your local government has exhausted those remedies and resources, then perhaps you would refer it to the Attorney General's office under a consumer protection action. But certainly not a tandem process, certainly not a duplicative process, certainly not one where the Attorney General was enforcing local code law, but something where you would elevate or escalate when you had local remedies that were failing someone is how it would work in a more linear process as opposed to parallel. And I believe she was having a conversation with them where that was made clear, but I don't know, maybe wires got crossed in terms of the drafting of that information letter. But it sounds like maybe it didn't, because at the end of it, it seems like they picked it up there.
Yeah, I appreciate the clarification.
Thank you.
Senator, okay.
Thank you, Mr. Chair. Thank you, Senator. So my question is about funding, capacity, timelines, and measurable outcomes. So given that August 31st, 2027 is the deadline for submitting the plan and recommendations, and the December 31st, 2027 sunset, what is DHCD's resources and staffing plan to expand the Office of Structure and follow up on inspections, relocation planning, and repair verification at scale? And what I mean is, what are the funding sources? Is there any state appropriations, fines, federal, local matching? What are we envisioning? And what are the metrics? So, I mean, at the end of the day, I mean, are we talking about how many properties, how many time-to-time violation, closure, tenant displacement? How are we going to demonstrate this to understand what the impact of the sunset is?
I really appreciate you asking that question, because I think it's one of the areas in the bill that got confused in the and people reviewing it and then opining in on the bill. The bill doesn't require the AG's office and Office of Landlord Tenant Affairs to conduct inspections and to stand up a new agency where they would do something similar to what code enforcement does. It requires them to look at their existing resources, their existing authorities, and then to come back to us in that 2027 date with an action plan that says, how can we take what we do and be effective for tenants that are living where they have a chronic bad actor landlord. So it wouldn't be that they were setting up a system where they were taking in complaints in that timeline and then had to clear those complaints, had to conduct inspections, and then had to finish that work by 2027. It would be that they had to do the kind of internal reviews to say, if we were a player in this and if we were a system where we were a part of the process and a part of the solution, what would that sort of, part of the solution look like? So it's more or less a study where they would come back to us with an action plan to say, if we were going to expand our functions and we were going to take on some of this to be effective for tenants, this is how we could do that work.
Okay. Thank you for the clarification. It just seemed like a short period.
I appreciate it.
All right, seeing no more questions, that ends the hearing on Senate Bill 941. Did you want to do your next bill?
Thank you, Mr. Chairman. Thank you. Thank you. Are we ready for 937? I think there's two panelists.
Right. Ms. Robinson and John Bay?
Yes. And Mr. Chairman, due to the rules of the committee, we do have just 2 panelists, but I do want everybody on the committee to know that there's broad support for the bill. And if you see folks that are in the room that are, I believe, in the blue shirts, if you just want to give a wave to the committee members, those folks are here in support of the bill, in support in spirit, if not in testimony. For the record, colleagues, I am Senator Shanika Henson, here to present Senate Bill 937, Maryland Fair Chance and Housing Act. This bill should sound familiar because we presented the bill to you all last year, so it is a reintroduction of the bill. What the bill does is, I believe, it builds on a lot of great work that this committee has done, and great work that we've done not just here in this chamber, but we've really taken the opportunity as a committee to familiarize ourselves, to understand. I know that during the interim, I got a chance to participate in not just being here, but going to our correctional facilities and going to the men's pre-release unit. We also went to the women's correctional facility and to see their pre-release unit at their correctional facility to see what it's like for folks who have served their time in incarceration and what opportunities are created for them to transition back into the community. I really see this bill as another part of the great work that this committee has done to help people transition back into the community after they've served their time and after they are coming home and looking to restart their life. After people are coming out of incarceration, you have to wonder what opportunities exist for them to find housing, and then you have to wonder if they can't find housing, what then happens to that individual's life, and how will they be able to put one foot in front of the other and find a productive path forward. So this bill gives them a fair chance at housing. What it does is it creates a 2-step process when a person applies for rental housing. The first thing that it does is it would require the landlord to give certain notices about a criminal background check when a person is applying for rental housing. So they would be notified upfront what sort of offenses the landlord can automatically disqualify a person for rental housing. So they would know if that person has those offenses within those time frames, then they would know the landlord could disqualify them for housing. That's important because a lot of times when you're applying for rental housing, there's a fee associated with it. So before you ever pay that fee, you'll know up front that the landlord could disqualify you for that. So you would know before you pay the fee if that sort of offense was applicable to you, so you have fair notice. The second thing after that is if the person then moves forward with putting the application in, it creates a 2-step process for the application. It would allow for a conditional offer for housing. So if the person qualifies based on their credit score, based on their working history, based on all the other metrics that the landlord can fairly consider, then the person would get a conditional offer for housing. But they would know that the conditional offer for housing is still subject to a criminal background check. So they would have that information up front, and they would know, I still have to pass the criminal background check, but in the beginning, if I pass the initial phase, if I've worked long enough, if I earn enough money based on the rent, if my credit history is good enough, then I get the first offer, and then I get to step 2. Step 2 is when the landlord can then look at the person's criminal history. So after the conditional offer, there would be a number of things for which the landlord could withdraw the offer still. So there's a number of offenses listed in there where the landlord could still choose to withdraw the offer. Among those offenses are some of the things that are the highest degree of severity. You can look through the bill and you can see what those offenses are, where the landlord could still withdraw the offer. But there are some things where we want people to still have the opportunity to have housing, even if they've committed those offenses. So we try to tailor that list to things that really are threats to the life and safety of a community of people living together in close proximity. So there are things like sex offenses, things like murder. We've heard time and time again in this committee, you know, there are certain offenses where if people are living in close proximity, that landlords have concerns about it, that people who are neighbors have concerns about it. So we want to be sensitive sensitive to that. Legislation on where people will live if they have committed those offenses will have to be something that some other senator at some other time takes up, because those folks have to live someplace too. But that's not what this bill does. What this bill does is for people who, have not committed those offenses, but others, it gives them an opportunity to have a fair chance at housing. So it also then creates a process where if a tenant believes that they have somehow, the landlord has misinformation, old information, it gives them a process to then go back to the landlord if they have been disqualified and given notice of it, to say, hey, I think you maybe gotten that wrong. I have additional information I'd like you to consider. So it gives the tenant some due process in the process with the landlord so that they can make sure their application has been fairly considered. So it really creates a process where criminal background checks are looked at with a little more regularity, a little more clarity, and a lot more fairness when it comes to deciding if a person can have a place to live or not. Because this committee understands acutely that having a place to live is not and should not be optional, that having a place to live should be viewed as a human right, and it should be viewed with a lot of dignity in the process. So Maryland Fair Chance in Housing is before you for consideration. I'll ask for a favorable report for Senate Bill 937, and I will turn it over to the panel. Thank you.
Good afternoon, everyone. I am here with BUILD, Baltimore's United Leadership Development, in strong support of the passage of SB 937, which would end discrimination.
And just for the record, your name?
I'm sorry, my name is Ramika Robinson.
Thank you.
I do apologize for that. Which will end discrimination in housing for most returning citizens in Maryland. Over the last 3 years, Bill and Turnaround Tuesday have listened to more than 1,000 returning home citizens and others directly affected by the criminal legal system. This represents a small part of more than 1 million people with a record who live throughout Maryland. We asked each of them what is the biggest roadblock for them coming home from incarceration. We heard story after story, but the #1 issue by far was housing. This is not abstract for me. I am here not just as an advocate, not as a professional working in reentry and education, but as a formerly incarcerated woman whose life was put at risk because I could not access safe housing. I served my sentence, but my punishment did not end when I was released. As a native of Washington, D.C., I was released into Baltimore with no family, no housing, and because of my record, housing options were closed off entirely. Even though I had been released, I still felt trapped, this time by policy, stigma, and systematic barriers. With nowhere else to go, I moved in with a former partner, and that situation became extremely abusive. If Fair Chance Housing had been in place, I would have had a real chance to choose safety over survival. Fair Chance Housing is not a reward or a handout. It is the foundation of safety. Maslow's hierarchy of needs teaches us that before growth or stability, people must first have safety. Without securing safe housing first, employment, education, recovery, and compliance all become unstable. This is not rehabilitation. This is a continuation of punishment. I strongly urge you to pass the Fair Chance Housing Act so that release in Maryland means safety, dignity, and a real opportunity to succeed.
Thank you.
Good afternoon, committee members. My name is John Bay. I am the director of the Opening Doors to Housing Initiative at the Vera Institute of Justice. We are a national criminal justice reform organization with years of experience implementing housing policies that further safety and justice. Today, I will testify in support of the Maryland Fair Chance Housing Act. This bill helps prospective tenants receive a fair chance at securing housing, specifically those who meet all tenancy qualifications but are denied because of their criminal record. We hear from landlords that this is to ensure safety. However, there is no evidence that excluding people with conviction histories makes communities safer. A criminal background check provides information about a person at the time of their last conviction, but it says nothing about who they are today, including the progress that they've made once they've returned to the community. In fact, most people with a conviction record never have another one. Considerations like a person's ability to pay rent, ties to their community, and employment status are useful in determining whether someone will be a good tenant. This law is written to balance the need for safety and justice with concern for property owners. One study shows that 4 years after incarceration, less than 2% of people make more than $50,000 per year. This means that most formerly incarcerated people cannot afford the average rent of $2,000 a month. Studies also show that with every year that passes after a person is released from incarceration, the risk of recidivating diminishes, eventually reaching a point that is equal to the general public risk of committing a crime. For most people leaving incarceration, it can take years to develop the financial stability required to afford a rental. Those who can overcome these challenges, demonstrate stability, and meet tenancy qualifications will be fitting tenants who pose no risk. Maryland deserves safety, justice, and economic prosperity. This bill delivers all three. I urge a favorable report on SB 937. Thank you.
Thank you very much. Seeing that there are no questions, we're going to move to Mr. Castelli from Realtors.
Thank you, Mr. Chair, members of the committee. Bill Castelli on behalf of the Maryland Realtors, and we are requesting an unfavorable report. I do want to address a couple of the points that have been raised today on the proponent panel and agree that when you are considering criminal history, you should be taking into consideration all of the things that they were mentioning. In fact, the HUD has structured a rule that has been in place for many, many years, and property managers, landlords, and others have been using it, which is to make sure under the disparate impact approach that you take into consideration things like the severity of the crime, when the time of the distance in time between when that person committed the crime. So we think that is an approach that's been used by the industry, that's recommended by the industry, and that at least property managers that we use have been trained in for many years. There are two bills moving before the legislature this year that actually are going to put that disparate impact approach into the state statutes here. So regardless of what happens with HUD, there would still be that approach. As to the bill itself, we do have concerns about the conditional offer. We think that there is a lot of liability that owners take when they rent property, and now making and creating a process where they now have liability for prospective tenants, not even tenants that are living with them, I think creates a disincentive for folks getting into the business. And I would say that, too, that in terms of the disincentives, one of the things that really concerns us are the penalty provisions that are in the back. There are criminal penalties if you don't follow this process appropriately for a landlord or property manager. And that gives us a lot of concern because we think when they're comparing two different tenants, because you will occasionally have tenants who are one with a criminal history, one without, it may create kind of a reverse incentive to go with a tenant that you don't have any criminal liability for. So for those reasons, we would encourage an unfavorable report.
Thank you very much. Seeing no questions, that ends the hearing for Senate Bill 937 and hearings for today. Thank you all.